I will tell you, Mr. Murdaugh passed the polygraph. Flying colors.
Lawyers for accused murderer Alec Murdaugh are dropping bombshells as they return to court to argue about evidence in Alec's retrial for the murders of his wife Maggie and son Paul. Will Murdaugh win motions to move the trial, get the case thrown out, and more? We're looking at all of the new details we're learning. I'm Angenette Levy, and this is Crime Fix. Alec Murdaugh is back in court, and he's fighting ahead of his retrial for the murders of his wife Maggie and son Paul. Maggie and Paul, you'll recall, were shot to death at the family's Moselle hunting estate on the evening of June 7th, 2021. Murdaugh called 911 after returning from a trip to his mother's home, Alameda, and told the dispatcher that Paul and Maggie were hurt badly. It took more than a year, but Alec Murdaugh would be indicted for Maggie and Paul's murders. Prosecutors with South Carolina's Attorney General's office said that Alec shot Paul with a shotgun and Maggie with a blackout rifle. Those weapons, they claimed, were family guns that never were found. Murdaugh was convicted swiftly, but won a new trial due to misconduct by the disgraced clerk of courts, Becky Hill. The state's high court found that Becky Hill tampered with the jury and vacated Murdaugh's convictions, sending it back for a new trial. Now Alec Murdaugh, his legal team, and prosecutors are back in court fighting over a lot of things. Everything from where the retrial will be held to what evidence the jury will hear and see and whether the indictments will stand. On that last one, they will. Fat chance the judge is tossing them, but you never know. Today's hearing in Lexington County was supposed to be about procedure, but it quickly turned into a fight over secret deals, alleged police misconduct, and even a bombshell claim that the Murdaugh murder weapons might be connected to another killing. Yes, you heard me right. I'll get to more on that in just a moment. But first, the hearing started with Alec Murdaugh's defense team accusing the state of possibly hiding evidence that could help Alec Murdaugh impeach state's witnesses.
As to secret agreements, there's a co-defendant in some cases, and then he's been charged separately. His name is Eddie Smith. Curtis Eddie Smith, who's a distant cousin of Mr. Murdaugh, was charged on November 2021, almost 5 years ago, of ab-hand, pointing and presenting, conspiracy, filing a false police report, and that's related to a roadside shooting that involved Mr. Murdaugh. Subsequently, in June of 2022, he was indicted by the state grand jury of 4 counts of money laundering, trafficking in meth, of other things. 4+ years have gone by, and those cases have not been disposed of. Every other case that we're aware of have been disposed of. And it begs the question, why not? Do they have a cooperation agreement with Mr. Smith? If so, what are those terms? He has been identified as a witness in this case since the last trial, well before the last trial. So we've got nothing on Mr. Smith. And if they have a deal, they're obligated to disclose it. If they have an understanding, they're obligated to disclose it, and we've never received it.
Now that's Cousin Eddie, a distant relative of Alec Murdaugh, who faces his own charges in a roadside shooting incident involving Murdaugh. The defense wants to know this: did Eddie cut a deal to testify against Alec? But that wasn't all. Griffin then turned to SLED agent David Owen, the lead investigator in the Murdaugh case, who also happens to be a former SLED Agent of the Year recipient.
With regard to credibility issues of police, we are aware that Judge Roger Young dismissed a murder case, and the name of that case is State v. Michael Colucci, and he was indicted in 2015. In June of 2025, Colucci's attorneys filed a motion to dismiss the indictment, saying that the state withheld critical exculpatory evidence on the eve of jury selection. The motions identify David Owen, SLED agent David Owen, who was the lead case agent in this case, who after this case received SLED Agent of the Year award. Judge Young dismissed the Colucci case because of withholding of exculpatory evidence. We want to know what's in Mr. Owen's SLED agent, I think he's retired now, in his HR file. Was he reprimanded? Was he sanctioned? Were any steps taken as a result of the Colucci matter?
Then it was the state's turn, and lead prosecutor Creighton Waters fired back. He said there is no secret deal with Cousin Eddie.
First of all, I want to say we take our obligations very seriously.
I know you do.
And have never had a problem. This is the first they've raised these specific issues. They could have given me a call, and if I ever discovered anything of importance, they're the first people that I call, and that's always been our practice. As to Giglio, as to Eddie Smith, they, of course, there is no cooperation agreement. I don't have any secret agreements. If I had any agreement with the individual, I would disclose that to him. They have all the witness statements. They have the state grand jury testimony. They've had every bit of information that we have on, and every bit of discovery that we have on Eddie Smith. And there are no secret agreements. And if I do ever engage in agreement with any witness, I will disclose that immediately to the defense. I understand that obligation very well.
Right.
Then the big bombshell. Alec Murdaugh's defense team claims that one of the Murdaugh murder weapons may have been used in another homicide. Take a listen.
We have learned through reporting from Fitz News that there was a recent murder, we believe, in Allendale County. And what has come out of that investigation and what has been leaked to the press is that Murdaugh murder weapons were connected to the Allendale County murder. Now, how could that be? And so we would like to know, were Murdaugh murder weapons connected to this Allendale murder? Now, if Your Honor will get into this, you'll learn that the SLED agent ballistic forensic lab did an analysis of just the shell casings on the 300 blackout that was used to murder Maggie Murdaugh. And the ballistics expert testified that the extraction marks on those shell casings found at the murder scene matched extraction marks found on shell casings around the Moselle home and at a shooting range. And their analysis was, in his opinion, it was the same gun that injected the shell casings of the 300 blackout at the house, at the driving range, and at the murder scene. Which leads us to, I mean, we don't know if it was the same murder weapon in Allendale, but if they did an analysis of the shell casings in the Allendale murder case, and they're saying it matches the shell casings for the Murdaugh murders, either their test is bad or someone's out there using a gun to murder other people.
Let that sink in. The defense is suggesting that the same gun used to kill Maggie Murdaugh could have been used in another murder. I'll get to what the state had to say about this in a second. And Griffin wasn't done. He accused the state of not taking their disclosure obligations seriously.
We are aware that SLED has received tips, because we've received tips. We've not been provided any information about tips of whether it's reliable or not, identifying anyone else other than Alec Murdaugh participating in the murders. We've not received any information. Have they found the murder weapons? Have they found the murder weapons since the last trial? And there's related information underlying all of those. And so we don't think the state is taking their obligations seriously enough to find out what Brady materials out there has been developed and what Giglio material out there has been developed. And this is what we are aware of today, but we don't have the benefit, we don't have the ability to contact law enforcement and get this information.
Assistant Attorney General Creighton Waters couldn't believe what he was hearing.
As to tips, we provided a lot of that information before, but as I said, this case was tried, over 3.5 years ago. And so we are in the process of, correlating. Heck, I get emails from all over the world to this day, but we characterize or categorize those, and there will be any sort of information, no matter how fanciful and far-fetched, and that'll be provided to the defense as well. And so again, that, as you recognize and as we recognize, that obligation is ongoing. We take it seriously, and anything that has developed since that time, we will make sure to provide to that defense. We are constantly always doing discovery audits and discovery checks.
All right, well, tell me about the Allendale with
I'm sorry, Your
the
Honor.
murder weapons.
That's the first I've heard of that. I have never heard the first thing about that. If somebody told me that they had matched that to the murder weapon, not only the first call again I would be making would be to them, and the second call I'd be making would be to Your Honor. That is the first I've heard of that. I've never read the Fitz article. Certainly nobody at SLED, who I communicate with on a daily basis, has said, hey, Creighton, by the way, X happened. So I will certainly look into that, but I would be flabbergasted to find out that actually had happened and no one had advised this office of that.
Okay. All right. I hope that answers your questions. He's going to get back with you. He's going to double check on Agent Kelly. But to his understanding, there was no dishonesty, but that would raise the bar to Giglio.
Yeah.
But he's going to get back with you. As far as the murder in Allendale with the murder weapons, you certainly raised my eyebrows on that.
Your Honor, throughout this case, Fitz News has been breaking stories that we were unaware of. And we can go through a long litany of that. But there was a podcast, there's a reference to what I just said to you.
Maybe you could forward that to Mr. Waters and let him look at it and see if there's anything to it.
But we would ask that they look into that.
And I'll be the first to say, Your Honor, is that I don't watch the podcasts and I don't read the blogs. I try to base what I'm doing on the evidence and not on speculation that's out there in the media. But I've never heard of that thing, and I will make inquiries. But it would blow my mind if something like that had happened in SLED and not call me. I communicate them daily. Their general counsel sitting here in the gallery here today.
The defense also wanted to introduce polygraph results related to cousin Eddie and Alec Murdaugh. Defense attorney Dick Harpootlian dropped an absolute bombshell.
Eddie Smith, who, as we've already understood, was charged with a whole bunch of stuff, had a proffer agreement with the state. And the proffer agreement was conditioned on him passing a polygraph. And as Mr. Waters knows, in other words, he had a deal, and the deal was predicated on him passing a polygraph. This is a copy of the results of that polygraph. And the polygraph was, did you kill Paul and Maggie Murdaugh? He failed it. And so they, relying on that, canceled his proffer agreement. Now, I'm not saying necessarily that's admissible on cross, but I am saying that it's an issue, not now, but much closer to trial, that we need to be able to litigate. And there may be others. We're going back through, I will tell you, Mr. Murdaugh passed a polygraph, flying colors. So the same polygrapher.
Now let me repeat that. The defense claims cousin Eddie, a potential witness, failed a polygraph when asked if he killed Paul and Maggie. Alec Murdaugh passed the same test. Creighton Waters fired back at that claim.
The case law is very clear in South Carolina that polygraphs are a no-no, and that's because while they may be an investigative tool, the reliability of them is questionable. And of course, even the U.S. Department of Justice manual notes that it's not a lie detector. What it does is record physical responses that, in the subjective opinion of the examiner, may indicate deception, but that deception may or may not be related to concerns of guilt or innocence. And that's why the courts have always rejected those, in addition to the fact that they go to the heart of why we have courts and why we have juries. And that's, of course, for the ultimate determination of the truth of the matter. And so, obviously, from the state's perspective, if ever there's a polygraph issue or there's an interview that occurred after polygraph, we are rock solid to make sure that witness and that officer or whatever does not say the P word out loud. And that's just been the general rule. And and this is the way I do things, just like we did the financial evidence last time. We laid all our cards on the table, did a long, extensive hearing. There was no gotcha moments or anything like that. And we just asked for the same thing, that there be, just sort of an in-camera ruling and an instruction that the polygraph word is not to be mentioned because, again, it can be hard to unring the bell. Your Honor, just to correct one thing, there's never been any sort of deal with Eddie Smith. A proffer is not a deal. It says in big bold letters, this is not a cooperation agreement. It's only, essentially a first aid provision. Again, polygraphs can be an investigative tool, but I never base decisions on them. And frankly, in my experience, I found them to be wrong, or for people to indicate DI for other emotional reasons than them to be accurate. This is why they're not ever relied upon in court.
Dick Harpootlian had the last word.
It was a proffer agreement. And the proffer is, you're going to tell us stuff, and if you pass the polygraph, we can go to the next step, which would be perhaps giving him something for his testimony. They were using it as a screening device, no question about it. But he failed the polygraph, so he didn't get the deal. He's right, he doesn't have a deal as far as we know. And the reason he doesn't have a deal is he failed the polygraph.
In the end, Judge McCaslin ruled the polygraph results are inadmissible. The jury will not hear about them.
I'm going to rule that the results of a polygraph examination are not admissible, as well as the defendant's willingness or refusal to submit to a polygraph. And I'm going to tell you now, there is to be no mention of a polygraph test before the jury. This ruling is based on counsel and case and the Palmer case. Should the defense seek to introduce any evidence or testimony or reference concerning a polygraph examination, you must notify the court and obtain a ruling outside of the presence of the jury, or risk this case being a mistrial.
If you love digging into the details of these big crime cases as much as I do, you must download the Law&Crime Plus app. If you haven't checked it out yet, here are 3 reasons to jump on board today. Number 1, you get complete access. Watch the best shows from both Law&Crime and Court TV completely ad-free. Number 2, the case files. Get deep dive access to raw trial evidence, including body camera video, 911 calls, crime scene photos, and much more. And finally, it's free for 30 days. We are giving all of our viewers a full month to test it out completely risk-free. So head on over to lawandcrimeplus.com, enter the promo code CRIMEFIX, and start exploring today. Now, one of the most important parts of a trial, picking a jury, of course. And we all know what happened last time with the jury. There was some funny business. That's why there's a retrial. Clerk of Court Becky Hill messed with the jury. And Murdaugh's defense team is a little paranoid that something could happen with jury selection this time around.
We would ask that there be direct supervision by you of the issuance of the jury summons, how they're picked. There were huge questions, obviously, after we learned of the clerk's conduct about how certain people maybe got on the Venari and others did not. She was apparently excusing people, we believe, and of course this litigation would help us. Litigation that's on appeal of the Fourth Circuit let us develop that. Her daughter appeared on the jury Venari, and she and I guess at the time either I nor Mr. Waters thought that was unusual, but she was talking to both of us about how she makes a great juror. She talked to me, I know she talked to you. I'm not saying expecting that to happen again. We've got a new court, but in terms of summonsing jurors, there's a process. The Supreme Court, I found out later on, that there's a list. Actually, they're generated in Columbia, and then the clerk excuses before she issues, he or she issues those summons. There's a screening process. That's what I'm concerned about. In other words, the big list will come from Columbia, but how it gets narrowed down before we ever see it, that would be me and Mr. Waters, concerns me greatly.
Again, this is the first that I've heard of any issues with that. I mean, my understanding is with Judge Newman's supervision, obviously a number of ones that were excused based on, patent exemptions, such as over 65 who claimed that were non-residency issues and that sort of thing.
Right. Would be my understanding of what normally happens
And when we
pick a jury here.
We had the whole panel arrive. Yes, there was something like that. Obviously, she was excused. There were also people that had close relationships with with Alec Murdaugh and the Murdaugh family. And of course, we vetted all of that and excused as appropriate.
Well, but what was never done, and I tried to get the list, compare the initial list that was generated in Columbia to what actually were summons that were issued. And certainly there were people that the clerk said,
They don't live here. They're over 65.
Right. Dead, whatever. I get that. But if we never got the original list, so we don't know. And again, call me suspicious, but when we have evidence that the clerk of court is attempting to influence the jury to obtain a guilty verdict so she could sell more books, when did that start? Did it start when she started winnowing down people she thought might be helpful to us? And I'm not saying that could happen again, but I think I need to mention it. I need to say to the court, I never expected it to happen the first time. I've been doing this 50 years. I've never seen the clerk of court interfere in this process. And clearly, our Supreme Court found she did.
Judge McCaslin agreed to oversee the process. Now, the next big issue, where will this trial be held? The defense filed for a change of venue. They don't want this trial held in Colleton County, or the jury picked from that county or the district where Colleton sits.
But everyone's going to know of this case, and everyone is going to perhaps have a preliminary opinion. The question is, can they put that aside and base their verdict on what you tell them and what they hear from the witness stand? So the second reason for Charleston is not only is it convenient, they've got a courthouse with 16 courtrooms in it. It's not going to shut down the county judicial system to try that case there. They did the Slager case there. Court operated normally, nationally covered case. Courtroom was packed every day, and it got a lot of attention. And right across the street, they tried Dillon Roof for 3 or 4 weeks. Didn't shut down the city.
But the state opposed the defense request to move the trial to Charleston, the defense's preference, to prove the point that Charleston wouldn't be too pricey. Dick Harpootlian actually called his co-counsel, Phil Barber, to testify.
Now, when we tried this case in Colleton County, do you know where the state folks stayed? They rented a big chunk of a Hampton Inn, did they not?
They stayed at a Hampton Inn. I believe it was at the Interstate 95 interchange.
Okay. And do you know how, and if you Google how long it takes to travel from that Hampton Inn to the Colleton County Courthouse?
I have not. I know that it took at least, I've driven it before. The Cracker Barrel was there when we went to there.
Oh.
It was it was a comparable 15-minute
Forgot
drive.
the Cracker Barrel was there. Yeah, it's about 15 minutes, right?
Yes.
About the same time it would take you to drive from one of those Mount Pleasant hotels, budget hotels, to the courthouse.
Yes, if you wanted to get in early, there's a lot of the hotels north of 17 have a highway on-ramp that's right there at the hotels without even having to stop light.
Okay, and does the Charleston County Courthouse have a parking garage?
It does.
And if we went to the Charleston County Courthouse, do you believe that we could get some spaces set aside for the prosecution and the defense and perhaps even witnesses to park?
All I can say is it would be incredible to me if attorneys for the state of South Carolina could not obtain parking spaces at a South Carolina, judicial facility.
Then it was Creighton Waters' turn.
When you testified earlier, you haven't actually talked to anybody at the court administration or at the clerk as to how, or that who manages that parking garage as to how many spaces could be, if any spaces would be reserved for anyone. Is that correct?
I have not spoken to the clerk about the parking.
All right. You would agree that Charleston, on a larger scale, probably has the most big city traffic of anywhere in the state?
I would not agree with that.
All right, where do you think has more traffic?
If you've ever driven through York County, the Charlotte traffic going into York County, I would probably nominate that as the worst in the state.
Okay, so second then?
The traffic here in Columbia, especially around the what's called Malfunction Junction, but also coming in, when I do come into Columbia, sometimes I'm staying a little north and come in down Bull Street. That is a nightmare every day.
So you're saying the traffic in Columbia is worse than the traffic during rush hour in the Charleston metropolitan area?
I'm saying that it's worse than the traffic coming from the Ravenel Bridge side of Mount Pleasant into Charleston.
Would you at least agree?
I want to, if I can finish, you had a very broad question about the Charleston metro area. It's certainly true that if you're coming in from Somerville, right, down I-26 in the morning, that is extremely difficult. But I don't think no one's going to be doing that. And I don't have experience with that. I've seen it. But coming from those hotels in Mount Pleasant every day to Charleston, it's a consistent 15 minutes.
The defense won the change of venue motion.
I find that the defendant has satisfied his burden under State v. Manning, where he's demonstrated actual juror prejudice. And unlike the ordinary pretrial publicity case, the evidence before this court is based on the actual results of the voir dire conducted in this case in the January 2023 trial. Fewer than 1 in 7 prospective jurors were qualified to serve, demonstrating an extraordinary degree of community exposure and prejudice. Second, under Reamer versus U.S., the interference with the jury process by an officer of this court is deemed presumptively prejudicial and cannot be measured by any voir dire. Ultimately, the decision to change venue lies within the sound discretion of the trial court, providing that a showing of actual juror prejudice is made. This ruling rests on 4 grounds. First, the exceptional rate of juror disqualification during the January 23 jury selection. Second, the community prejudice arising from the size of the county and the long-standing association between the defendant's family and the 14th Circuit. Third, the South Carolina Supreme Court's determination that the former Colleton County Clerk of Court improperly influenced the jury, depriving the defendant of his constitutional right to an impartial jury. And fourth, the form of publicity surrounding this case. There's case law that says I can't transfer something just for publicity. That can be cured. But with the 4 grounds that I've just stated, I am transferring it.
Judge McCaslin hasn't said where the trial will be held. And finally, Judge McCaslin handed the prosecution a win, saying prosecutors will be able to use Alec Murdaugh's testimony from the first trial as long as it's relevant.
Obviously, as a general rule, under Harrison, a defendant's testimony at a former trial is admissible, and I'll get to the statute in a second. And then I'll also, of course, under Rule 804A1, it would be admissible, of course, based on unavailability, assuming that he would refuse to or exercise his Fifth Amendment right at a second trial. The issue, of course, boils down to the statute. And of course, the statute says that the testimony of a defendant in a criminal case shall not be afterwards used against the defendant in any other criminal case except upon an indictment for perjury. And of course, our position in that is that this is the same criminal case. This is not an other criminal case. It's the same indictment. It's the same allegations. It's the same case that we are doing.
The defense had objected to Murdaugh's testimony coming in at the second trial, which is set for April 2027. So stay with us here at Law and Crime for the very latest on this case as it unfolds. And that's it for this episode of Crime Fix. I'm Angenette Levy. Thanks so much for being with me. I'll see you back here next time.